Hello, welcome back to Legal Brain. In today's class, I'm going to discuss yet another important area, and that is dissolution of a firm. So, in exam point of view, I'm going to discuss about what do you mean by dissolution of a firm? What are the modes of dissolution based on Indian Partnership Act 1932? So, let's listen to the class. So, first of all, I would like to start the class with, defining the meaning of dissolution. What is dissolution? So, in simple words, the dissolution of a partnership between all the partners of a firm is known as dissolution of a firm. Like I'll give you an example. Like imagine there are six partners, and there is a firm. So how can we say that this particular firm is dissolved? Dissolution meaning is like winding up. Winding up is the meaning of dissolution. So how we can say that this particular firm is winding up? The answer is that the dissolution or winding up of a partnership firm happens when the dissolution of partnership between all the partners of the firm is dissolved. So that is the meaning of dissolution. So the firm is dissolved when all the partners stop carrying on the partnership business. And also if some partners, for example, they dissociate with the firm, and remaining partners they continue to do the particular business as a firm. If this is the situation, the firm is not dissolved in this particular aspect. So thus dissolution of a partnership between all the partners of a firm is known as dissolution of a firm. So this is the meaning. Winding up or dissolution meaning is all the partners of the firm should come to a conclusion that we are going to wind up the business. So now, what are the different modes of dissolution? So this is an important area, different modes of dissolution. We do have 5 modes of dissolving a particular firm. So according to Indian Partnership Act, the first one is dissolution by agreement, that is by virtue of section 40. Second is compulsory dissolution by virtue of section 41. Next is dissolution on the happening of certain contingencies, that is section 42. And dissolution by notice of partnership or will, that is section 43. And dissolution by court, that is section 44. So in today's class, I'm going to discuss in detail about all these 5 modes, and I'm going to discuss like what is the meaning of all these different modes. So first, I'm going to discuss about dissolution by agreement, which is mentioned under section 40 of Indian Partnership Act 1932. So what is that? So by virtue of section 40, a firm may be dissolved with the consent of all the partners or in accordance with the contract between the partners. The meaning is that there should be consent of all the partners. Imagine there are 6 partners. Then all the 6 partners should give the consent to wind up the business of the firm. Or, it can be actually wind up with regarding the consent of the partners, or also in accordance with the contract between partners. For example, the contract was for like 2 years. So after the completion of 2 years, we can actually dissolve or wind up the firm. So this is based on the agreement. And section 40, which includes mainly 2 modes. The first one is a firm may be dissolved with the consent of all the partners. As I've told you, if there is consent of all the partners, we can wind up it. So according to this mode, a firm may be dissolved at any time with the consent of the partners. Second one is that a firm may be dissolved in accordance with the contract between the partners. I've told you, if the contract is for like 5 years, after the completion of 5 years, we can actually wind up the business. So this contract may either be partnership deed through which partnership is established, or by any other contract between the partners. So if the partnership deed contains any provision regarding dissolution, then the firm has dissolved accordingly. And besides, this partnership contract may be dissolved by any other contract. So these are the different 2 modes under section 40 with consent. Point number 1 and point number 2 is according to the contract. So these are the 2 points falling under dissolution by agreement by virtue of section 40. Next, second one is compulsory dissolution based on section 41. So according to section 41, compulsory dissolution happens in certain grounds. The first point is all the partners or all the partners but one becoming insolvent. So here, when we learned about the valid essentials of contract, we have learned that, the particular persons who are entering into the contract should be competent to contract. There should be competency and they should not be insolvent. So that's the basic condition. So based on that, if at all, like any of the partner or all of the partner became insolvent, then that leads to a compulsory dissolution of the partnership firm. Based on section 41 subclause A, it is defined that a firm is dissolved by the adjudication of all the partners or of all the partners, but one becoming insolvent. So that is the point. If anybody of them is becoming insolvent or all becoming insolvent, that leads to a compulsory winding up of the partnership firm. And we can also made a reference to section 34 subclause 1, in which provides that a partner in a firm as adjudicated and insolvent, he ceases, that means he stops to be a partner on the date on which the order of adjudication is made, whether or not the firm is hereby dissolved. So the meaning is that whenever there is an adjudication by court, an order passed by court that this particular person is insolvent, from that point of onwards, the particular partner ceases or stops to be the partner. So thus, if a partner is adjudicated as an insolvent, he ceases to be a partner. So that is the first point falling under compulsory dissolution. That is all the partners or any of them becoming insolvent. And I have discussed this similarly, where all the partners, but one is adjudicated as an insolvent, the firm is compulsorily dissolved based on the, in order to have the competency to contract or to carry on a business, the particular partner or person should not be insolvent. Next is second point under compulsory dissolution, that is happening of any event making the business of the firm unlawful. So I'll explain it in a very simple words. For example, me along with my partners, we were doing a legal business which is purely legal and there is no complications, but later on turned into an unlawful business, or there is an element of illegality. If that is the situation, the firm has to shut down immediately and we lead to a compulsory dissolution. So it means a firm is dissolved by the happening of any event which makes it unlawful for the business of the firm carried on or by the partners. So which is mentioned under section 4040 subclause B. So if at all the business is going to turn into an illegal business or an unlawful element in it, we have to lead to a compulsory dissolution. So, and also another important area falling under this particular concept is doctrine of severability. That means, in simple words, if there is an act, for example, if there is an act and the act includes certain provision which is illegal, and if it is separable, we have to separate it and makes the other part of the act, valid. If not, suppose if it is inseparable, we cannot separate the illegal part or, the part which is not lawful, and we cannot separate it. We have to, when it leads to a situation in which is not valid. So in simple words, if, only the part which has become illegal shall be void and the legal part remain valid. So similarly, where the business of the firm consists of several undertakings or adventures in which some of the part is illegal in nature, we have to avoid or cut off that particular part. That means by avoiding such business and makes the whole business legal. So doctrine of severability is applicable in this particular case. In the happening of an event, if it is making the business unlawful, and if it is separable, we just have to remove it, apply doctrine of severability and makes the whole business valid. If not, that leads to a compulsory dissolution. And third point is, this is like next mode of dissolution, that is dissolution on the happening of certain contingencies, happening of certain events, which is based on section 42. And let's discuss what are the different contingencies. First one is by the expiry of fixed term. For example, the particular business is to be carried out within 1 year. After the expiry of 1 year, we have to dissolve the particular firm. So a firm is dissolved, constituted for a fixed period of time, and by the expiry of which that lead to a dissolution based on section 42 subclause A. And the second point is on completion of adventures or undertaking. For example, this is based on section 42 subclause B, and the meaning is that if we enter into a partnership in order to carry on a particular business or an undertaking. So after the completion of such adventure, for example, it took 10 years to complete this particular adventure, let it be. So after the completion of, it's not time period, it's about the completion of the adventure or the undertaking. So once when it is completed, for example, it was like we predicted that it will take 10 years to complete this adventure or undertaking, but it only took 2 years. So we can wind up the firm after 2 years based on section 42 subclause B. The third point, C, is by death of the partner. So, it's uncertain. We can't predict it. So, subject to the contract between the partners of the firm is dissolved by the death of the partner based on Section 42 subclause C. So, the main reason of this rule in law is that law firm is not a person. It is only a group of persons, and the name of the firm is only the collective name of the person who constitute the firm. So in simple words, the name of the firm is a mode of describing the persons who have agreed to carry on the business. So if any of the partner is dead, that leads to a dissolution of the firm. And next point is by the adjudication of a partner as an insolvent. I have already discussed about this point. So it's the same thing. If any of the partner become insolvent, that lead to a dissolution. And it is again a contingency. It may happen or may not happen based on Section 42 subclause D. And the fourth mode of dissolution is dissolution by notice of partnership at will. So this is by virtue of Section 43 of Indian Partnership Act 1932. So based on this, if you want to dissolve a particular firm, dissolution can happen by notice of partnership at will. The meaning is that the firm be dissolved by any partner giving notice in writing to all other partners and communicating his intention to dissolve the firm. So, but it has certain points. So, in order to dissolve the firm, we have to satisfy the following conditions. A notice should be sent and it should be in writing, and it must express the intention of the partner to dissolve the firm, and the written notice must be given to all the partners. So, these are the conditions in order to dissolve a firm by notice of partnership. And the fifth mode of dissolution is dissolution by court, which is falling under Section 44, and which has certain sub points when a court can grant a dissolution of a firm. First one is a partner becoming of unsound mind. A person, become an unsound mind, and at the suit of a partner, that the court may dissolve the firm on the ground that the partner has become unsound mind. A suit can be filed by the partners to dissolve the firm. This is based on Section 44 subclause A. And next one is based on 44 subclause B, and that is a partner becoming permanently incapable. For example, a partner met with an accident and he become permanently incapable. Permanently incapable means doesn't mean fractures or a bone fracture or nothing like that. Permanently incapable means the person cannot function, like he went into coma stage or something like that. It's permanently, there is no coming back. So if that is the situation, the meaning is permanently incapable. Doesn't include temporary incapabilities like fracture, ligament tear, and so on. It only meant permanent incapability, and that is like falling brain dead, coma, and so on. So this is based under Section 44B. So that is a situation, so it can be filed and can lead to the dissolution of the firm by court. The third point, C, that is based on Section 40 subclause C, that is a partner guilty of conduct likely to affect prejudicially the carrying on of the business. So that's it. The simple meaning is that if at the suit of a partner, the court may dissolve the firm on the ground that a partner other than the partner suing is guilty of conduct. He have done something something which is not falling under the contract, like he did a misconduct which is likely to affect the carrying on of the business. He have done a crime which is falling under IPC, and so on. So if that is a situation, that can lead to a compulsory dissolution by court if it is a suit is filed by the other partners. And D, that is based on Section 40 subclause D, and that is willful or persistent breach of agreement relating to the business or management of the affairs of the firm. So the meaning is that there will be an agreement, a partnership deed, when to carry on the business. And if any of the partner made a breach, which means a violation of the agreement relating to the business, or it can be based on the management of affairs of the business, then we can file a suit to court to get a compulsory dissolution by court. So this can lead to dissolution of a partnership firm. And next point is E, based on Section 44 subclause E, that is transfer of all interest of the firm by a partner to a third party. So the meaning is, for example, I am a partner and I have transferred all the interest to a third party, an outsider, and who will have no interest left in the firm, and therefore it can lead to a dissolution of a firm if a case is filed in court. And the next point is perpetual loss based on Section 40 subclause 4. That is a suit of a partner if you can file a case in court in case if the ultimate objective of the partnership firm is to gain, profit. Suppose we are trying a lot, but we cannot get profit out of the business. It is always loss. If that is the situation at the suit of a partner, the court may dissolve a firm on the ground that the business of the firm cannot be carried on such loss. And the last point falling under dissolution by court is just and equitable. The meaning is simple. If court find it just and equitable that it is better to shut down the particular business which is carried on by the particular partnership firm, then at the suit of the partner, the court may dissolve a firm on the ground that is just and equitable that the firm should be dissolved based on section 40 subclause D. So the dissolution of partnership by court, that mode is a little bigger. That is like there are different modes from section 40 subclause A to section 40 subclause G. So these are the different modes of dissolution of partnership firm, and the meaning and in detail I've discussed about dissolution of firm. This is an essay question. I hope it's clear for you. If you do have any doubt, do comment below and check the notes in the description box. Thank you.